Hey, welcome everybody. Thanks so much for attending. I'm George Contreras. I'm the chair of the AALS Art Law section this year, and I would like to welcome you to the first of our periodic informal webinars for the Art Law section. We plan to have a number of these over the course of the year, and hope that you'll be able to join us for many more. I'm especially excited about today's event. We are going to be talking about the really amazing new book, Painting Constitutional Law, Xavier Cortata's Images of Constitutional Rights. And here, I'm going to just share this so you can see what it looks like. The book came out this year. Matthew Miro and Howard Wasserman are its editors, and it has contributions from a number of prominent constitutional scholars, plus 10 wonderful artworks by Mr. Cortata, who we'll hear from today as well. And so with that, I am going to turn the floor over to Howard, who will act as the moderator of today's session.
Excuse me. Thank you, George, and thank you to the Art Law section for putting this all together, and thanks to all of you for joining us. And it sounds like we really got a great response to the program. Xavier Cortada put together May It Please the Court as a series of paintings depicting major cases by the Supreme Court of the United States that originated in Florida. The original series consisted of 7 paintings. The earliest was Gideon versus Wainwright in 1963, which is the cover image. And then the latest was Seminole Tribe of Florida in 1996. The series premiered in a display in the Rotunda at the Florida Supreme Court in 2004. The paintings have been on display at FIU College of Law since the early teens. And this project really was the brainchild of my friend and colleague, Professor M.C. Miro, who was inspired to combine legal analysis with the study of visual art. And then I was very fortunate that he came to me to work with him on the project because I dabble in constitutional law, and so I knew people in the area. And then Xavier was kind enough to supplement the original 7 paintings with 3 more cases post-2000, including Bush versus Gore, which brought us to a nice even 10 cases, and also brought us up to date on Florida's contribution to the U.S. Constitution through the Supreme Court. So I want to start the program by introducing my co-editor and the brains behind the project, M.C. Miro. The full biographies for all of our presenters are on the registration website, so I'm just going to hit some of the highlights. Matthew Miro is professor of law and a founding faculty member at FIU College of Law, as well as a member of the Florida Bar. In 2019, he was elected a vocal of the, and forgive my Spanish in advance, the Instituto Internacional de Historia del Derecho Indiano, and a corresponding member of the legal history section of the Academia Nacional de Historia in Argentina. He has been a McCormick Fellow at the University of Edinburgh Law School, a Fulbright U.S. Visiting Scholar in Chile, a Menshikoff Fellow at the University of Miami, and a Kelly Lecturer at Davidson College. He is on the Board of Editors of the Law and History Review and a co-editor of the Legal History Library published by Brill. Professor Miro, welcome.
Thanks very much, Howard. Thank you, George, and thank you, Howard. Thank you, Xavier, for these challenging works of art that explore and critique American law and justice. For me, this was an incredibly fun project, and I'm hearing that from the contributors and heard that from the contributors over the course of discussing this project. And so I got to work with and learn from all of the scholars who were involved in this. And it left me with a permanently expanded area of thinking about image, law, public art, and ways that these can improve our world. As a legal historian, I've been working on Florida legal history for about the past 10 or 12 years, but mostly in the colonial period, in the Spanish colonial period, in the British colonial period, and in the 19th century. But Xavier's paintings are and were part of my daily life. They hang in the halls of our law school. And so it was this connection to Florida and the way that Florida connected to national legal developments that caught my eye, if I could say. Howard and I decided that it would be fun to assemble essays about the paintings and cases, and it was really an experimental project. There were various points of engagement with this project, with our own work, but other aspects that were far beyond our areas of expertise. So we were often diving into things that were unknown to us at the beginning. My chapter serves as somewhat as an introduction. It attempts to tie what our contributors, the chapter authors, Howard, the paintings, Xavier, and I are trying to do into the general trajectory of scholarship on art, image, iconography, and law. There was no real precedent for what we were doing, particularly with a contemporary artist, contemporary art, and relatively recent legal developments. But there were several scholarly vectors that pointed to or pierced through this experiment, and that's what I want to describe just very briefly this afternoon. So there are two main schools or approaches or groups. The first group, looking at legal iconography, is a more traditional approach of European legal historians who deal with legal image, mostly from Northern Europe, from England, Germany, Belgium, the Netherlands. And there were at least two important exhibits that focus in this group or this area. There was one in 1995 on the 500th anniversary of the German Imperial Court, and then about 4 or 5 years ago, a very large exhibit in Bruges on art and law. Both of these exhibits focused on classical European art up through the beginning of the 19th century. Their themes draw from predominantly classics and Christianity, the common depictions of justice as a woman, and here there's a whole subcategory of literature about how justice is depicted. You've got justice blindfolded, you've got justice sighted, you've got justice with a sword, you've got justice with scales, you've got two-faced justice, and even some instances of a decapitated justice. Can you hear me now? I was momentarily muted. Yeah. Did I leave off with speaking about justice?
Decapitated justice was the last thing.
So we're great. Okay. Yeah. Judgment, heaven, hell, secular justice, all of these things. Many of these things were public works for courtrooms or town halls where deliberations were made. There were paintings, sculpture, furniture, architectural details that were there to remind the participants to be honest, not to lie, to balance justice and mercy. So that's one group of scholars who look at mostly Western European art or European art. A second group are social and cultural historians with modern theories of legal image. Many of this group are from North America, and their work is much broader in scope, with specific training in art history, aesthetics, and criticism. They've begun to replace notions of legal iconography with ideas of imaginal law or pictorial law, really expanding the borders of this relationship between image and law. And as they've done this, they've also moved into a number of different forms of media, photography, film, architecture, public space, and street law. So this study, what we've done here is added to this stew of these various approaches. There are some differences. The contributors are scholars of constitutional law, and so we're viewing these works through their scholarly expertise in that field. There are contemporary paintings reflecting US Supreme Court cases. And in many ways, I think they reflect common law thought generally. These are specific cases with specific facts. And so one of the attributes that, particularly for law professors, we're always focusing on these facts in class and stating how important they are for our students. These paintings really reflect that perspective, that is the facts and the people at the center of May It Please the Court, Xavier's series. Abstractions like justice, mercy, and prejudice are really depicted here on the ground level in the lived experience of the people in these paintings. So these works of art also reflect place. As I mentioned, my interest is in Florida legal history, and here we have a beautifully varied and unpredictable place when we talk about Florida. These cases and the paintings illustrate this point. Gideon, the Miami Herald, Florida's electric chair, Jim Crow mentalities, Santeria, the Seminole tribe, environmental erosion, pot-sniffing dogs, and including something that seems to continue, Florida's place in national political theater. All of these things can be found in this exasperating state, and all of these things can be found in the captivating colors of Cortada's palette. Thank you.
Thank you, Professor Miro. We now will turn to hear from the source of the artwork. Xavier Cortada is an artist, professor of practice at the University of Miami Department of Art and Art History, an artist in residence at Pinecrest Gardens, where his studio, gallery, and socially engaged art practice are based. Using art's elasticity to engage others, Cortada educates and inspires community members to work and learn together to solve our community's problems. Cortada's work is intended to generate awareness and action toward issues of global climate change and social justice. He created art installations at the North and South Poles to address environmental concerns at every point in between. In 2007, as a National Science Foundation Antarctic Artists and Writers Program Fellow, he used the moving ice sheet beneath the South Pole as an instrument to mark time. The art piece will be completed in 150,000 years. Maybe we'll write a book about that as well. In 2008, he planted a green flag at the North Pole to reclaim it for nature and launch an eco-art reforestation effort. Cortada was born in Albany, the son of Cuban exiles. He grew up in Miami from the age of 3. He holds a Bachelor of Arts from the College of Arts and Sciences at University of Miami, a Master of Public Administration from Miami's Herbert Business School, and a JD from the School of Law. Welcome, Xavier.
Thank you so much. It's such an honor to be here, not just with those who helped contribute to this beautiful book, but also, and more importantly, with a new generation of scholars, a new generation of individuals who are studying, literally devoting their lives in the pursuit of justice. And as I look at my country and the world, with its polarization, with the kind of voter suppression that I am seeing, with the lack of equity built into our structure of governance and across the board, everything that flows from that, racial and social inequities that are perpetuated time and time again. And when especially, I look at a planet undergoing a climate emergency, indisputably undergoing a climate emergency that will bring suffering to billions of human beings, that will cement the sixth mass extinction that will bring heat again next year, never recorded before in human history. And if we don't act quick enough, the kind of heat that will cause nation states to collapse, famine, hunger, and war. That is the precipice of catastrophe that I'm staring at right now. And I remember a long time ago when I was a law student, I was lucky enough to have been selected by my peers to be the governor of the Fifth Circuit of the American Bar Association Law Student Division, and then the national vice chair, and eventually a division delegate voting in the ABA House of Delegates as a student. And those perspectives are surrounded by legal thinkers and scholars and everything from individual rights and responsibility, right, all the way through the various sections of the ABA, really informed me. And I remember an incoming ABA president coming to our law student event. And, sort of, I think all of us have heard the sort of quoting Shakespeare's phrase about, the first thing we do is kill all the lawyers. He didn't get a chuckle because he immediately answered by saying, you kill them in order to destroy society. You erase them, you silence them in order that democracy and society not continue in an equitable way. Law is a social science. It is the ultimate way that we as human beings work together and navigate in a world of close to 8 billion people. So it is no wonder that an artist who was informed by his law degree, literally informed, my work as an artist, as a socially engaged artist, is informed by the courses and the professors and the students that I learned from while I was at the University of Miami. And as a socially engaged artist who, to this day, continues working to address issues of children in adult prison, right? Using art as a way of engaging in advocacy, using a tool for advocacy, it should be no surprise to anyone that I would have come up with works like the ones we're discussing today. And I go through this to really actually inspire the professors and the students who are on this Zoom call to continue to devote yourselves passionately to your work, to understand that it isn't just about you, but literally it is about what you do to effectuate lasting, positive, and meaningful change. And I do believe that out of all disciplines, law is about as interdisciplinary as it gets. If you think about the different studies and the different ways that we approach our society through law. I mean, law is the way we behave. That's what manages the way we behave with one another. So I actually am honored to have my paintings integrated into this law forum, but intentionally want to focus on that because I want to invite the lawyers to get outside of their silos, and not just in the way you think about law, but in the way you do life. I remember as an ABA student, and again, we were students, so you're in New Orleans, you're going to go to Bourbon Street. But as ABA students, I remember that a team of us would go to art museum. Would literally one evening, a whole group went to ballet. So the idea of expanding our cultural horizons, engaging in community, understanding that there's an entire world outside of your campus, your law school campus, and especially working through clinics and working in community. And importantly, by volunteering and reaching out to others, not only do you become a stronger advocate, a stronger litigator, a stronger attorney, but a more engaged, ethical human being who can help others understand their place in this world and try to leave this world a little bit better than how you found it. Let me go ahead and share my PowerPoint presentation to you, but it was important for me to put that in perspective, like, why is this work happening? Well, there's a reason for this. So I'll go ahead and share my PowerPoint now. And Howard, please let me know, when time's up. Let me know 5 minutes ahead of time if you don't mind, okay? Thank you so much. Just speak, because I won't be able to see the chat room.
You're
All right,
doing
so
fine.
thanks so much. So, painting constitutional law. This was an exhibit that occurred at the Supreme Court, but before I get started, I really want to offer my profound gratitude to both MC and Howard, who came to me with this idea and who really helped me in developing, in fact, selecting the last 3 paintings to end this series. I also want to thank Renee Atter, who is the art historian who wrote a beautiful chapter that put my work in context. What I was trying to do in the last 5 minutes, she did so eloquently in her chapter, explaining why this artist, why this art. And I'm especially indebted to the legal scholars, the constitutional scholars, the bright legal eagles who help us understand our Constitution, how it is that we ensure that we live up to the promise of what we should be as a nation and as citizens of the world. I want to thank them for the honor of doing more than having a conversation with my art, which is what most people do. When you see a painting, it doesn't come alive until you interact with it, right? A painting needs a viewer for it to be a painting. And in this case, they didn't only communicate with that painting, but they shared what they saw in that communication with everyone else. And they did it in such a compelling, powerful way. I am literally humbled by the time and care they took in capturing what they saw in these paintings and sharing it with you. And there's a name that's nowhere on the book, but I guess I should give him a little credit. Frank Jimenez is my little brother at Lambda Chi Alpha. We both went to the University of Miami and studied. We were both studying biology together. And then we both decided to go to law school. And he went on and is a really, he's a general counsel for a major Fortune 500. He worked, for the Bush White House. He worked for Governor of Florida, all in his capacity as an attorney. And in 2004, because he's my buddy, I reached out to him and started brainstorming with him as to which cases I should look at. Gideon was obvious, but he and I went back and forth in this collaboration in exploring cases. So although both MC and Howard get credit for the last 3, I just want to give Frank Jimenez credit for the first 7 in helping inspire me the same way both of you did. So with the project, the idea of may it please the court came from a need for me to communicate with a third and co-equal branch of government. And apparently they were pleased. There was a Florida Bar article written about the exhibit, and Justice Parente, who I'm pictured with here, she said, "I'm just amazed by the power of some of these paintings," said Justice Parente, "and I'm just overwhelmed that Xavier would have created these paintings just for this exhibit." Well, she was half right. I did create them for that exhibit that opened in 2004, but I never imagined the book, but I really created it for the people of Florida, for the people who served in Florida. And over here, you see the paintings hanging in the rotunda. Next to her is Justice Cantero. I clerked for him, and he is the one who nominated my work to hang in that court. And it was part of that court for 5 full years. And all of the paintings, except for this one, apparently, were displayed in different parts of the Supreme Court. This one, Prophet, and we'll obviously be talking about it, was actually put in a closet after the exhibit came down a few months later. And I think, obviously these justices decide capital cases in Florida, but for whatever reason, that was the fate of that particular painting. The work were the paintings in this book, but there were other works, and I kind of want to tell you about that to put the exhibition in context. So I had created a painting to commemorate, and this painting also hangs at the clinic at FIU, to commemorate the repeal of a human rights ordinance that had, there was a human rights ordinance against gay people in society in Miami. And I remember when I wrote this piece, something that happened back during the days of Anita Bryant, that I wanted to address the issue. And again, in this Bar Review article, and the reason I'm trying to place myself then is because I want you to not hear from the Xavier today in context, but the Xavier is a 39-year-old who talked to a journalist back then. And it says, this is a strike. It talks about, I use art as a tool for advocacy, and it says, this is strikingly apparent in his acrylic and oil triptych titled "All Are Equal, but Some of Us Are More Equal Than Others," an Animal Farm reference. The idea is, the point this is me being quoted, the point I'm trying to make is that when there is one insular minority, where there is one group of citizens targeted or in any way diminished, all of us as human beings are diminished, and our society becomes less free. When our society is less free, every single one of us is less free. And I continue, this piece is timely, and it is about me. As an openly gay man, I am really concerned about what our society is doing, particularly today. If you remember 2004, there were a couple of amendments that were put in the Constitution, wedge issue amendments, about banning gay marriage across the states. So I was responding to that moment in history, particularly today, and how easy it is to marginalize people. It is done to gays today as it was done to African Americans. It is the civil rights issue of our time. So it is important for me to have this piece here. Hopefully it will open some minds. So the idea about parente, may it please the court, I was trying to basically please the court, but more importantly, I was using art as a tool for advocacy. And here I am describing the painting to Justice Quince, who said about the entire exhibit, studying the symbolism in the paintings, she said, "I love having art in the court. This is a especially good exhibit because it's about the legal profession. Many of these are about the cases that we are actually deciding here today." And in a way, I was also trying to open not just society's mind, but again, the way I do with scientists today through my work, where I try to let them to show their creativity or help them think of themselves in more creative ways, more open ways. I was trying to show justices different perspectives from the very cases, the very case law that they use in deciding their cases, by allowing their minds to come in and interpret these paintings and what they meant the same way that our legal scholars have in here. Another case that hung there was a case called Convictum. And over here, when I'm talking about the Convictum piece, I begin talking about kids in adult prison and what happens, what the force of government is on populations. It is a piece that I did with the Public Defender's Office along 2 years earlier, along with these two pieces that I did in 2002 and 2003. These pieces were created for the University of Miami School of Law Children and Youth Law Clinic, but they were about voice. They were about therapeutic jurisprudence. They were pieces where I was trying to allow folks to understand that individuals needed to have voice, especially younger individuals, if the therapeutic intervention of the sentence that they were receiving was to have an effect, they should feel that they were empowered, that they had voice, and not just through their guardian ad litem, but they themselves were heard. It's a piece that I took to the juvenile courts. So it's not only at the Florida Supreme Court. By the time I got to the Florida Supreme Court, my art had already been in other courts, including at the Juvie Courthouse in Miami-Dade County back in 1999 to commemorate 100 years of juvenile justice. And in here, I had individuals who had been arrested across, across Miami-Dade County, children, write messages for future children who would be able to do that. And I did this as a way of pro-social bonding, giving voice to the very kids who were adjudicated in that building. So again, you can see how I use my art as a tool for advocacy, as a way of engaging about sharing different perspectives. And that leads us to, of course, these 10 cases that I created. Gideon is about voice. It's about one individual being able to change the course of history. The work with the jurors is about your role. It is as pure as it gets for you in our three branches of government. You come together, you decide. Truth comes together when the six of you come together, just like the colors of a prism are diffracted from white light. There's a purity that comes about that. As a son of Cuban immigrants who exiled and lost everything in a totalitarian regime, the idea of a free press. There's going to be a lot of discussion about this work today, but I was particularly disturbed by I'm not going to call it callousness, but I will, or the lack of emotion, the stripping of all emotion when all of us, through the work we do, by voting, by being engaged in society, have a firm hand on the grip of whether or not someone dies or not. But we remove ourselves, and then those who make the decision use formulas, and it all looks very removed. But it's a difficult decision made by human beings, and I just want us to own that. And that's what this painting was about. I think there's a reason why it lived in a closet. Again, also looking at different perspectives and diversity in society, a community like ours with our indigenous populations, helping understand the different perspectives that help shape Florida history. And in my mind, the missed opportunities to make our society feel that every vote counts and every individual has voice. Something that, again, as I started my conversation, is happening across legislatures in our nation today. So these are the works that I produced, and I'm so honored to have had the opportunity to share those with society, to share it with all those law students at FIU, and clearly through this book to broader audiences in conversations with legal scholars whose life work is to address these kind of concerns. It's been my true honor to have been part of this exciting experiment, as MC called it. Thank you so much.
Thank you very much, Xavier, for those words. So now I want to turn to three of our contributors to talk about their chapters and the associated works. We were really very fortunate to attract a really great group of authors to work on this project with us. And they were up to accepting a really unique challenge to not only write about cases that they've taught and written about and spoken about for years, but also to engage with Xavier's painting and with the visuals. So they're not only telling the story of the case, but they're also telling the story of the painting, the story that Xavier was trying to tell through his work. And the three people who are participating in this program today did an especially good job of this. We're going to go in chronological order of the three cases that are depicted, but each is especially Florida. Each case is especially Florida in its own way. So our first speaker is Karina Barrett Lane. She is the Roberts and Sandra Moore Professor of Law at the University of Richmond School of Law. She is a constitutional law scholar who writes about the influence of extra legal norms on Supreme Court decision-making with a particular focus on capital punishment. Her scholarship, which often uses the lens of legal history, has appeared in Stanford Law Review, University of Pennsylvania Law Review, Duke Law Journal, UCLA Law Review, and Georgetown Law Journal. She is an elected member of the American Law Institute and received the University of Richmond's Distinguished Educator Award in 2006. She's a former prosecutor and an Army veteran. She will be talking about Proffitt versus Florida, the 1976 case, in which one of three cases in which the Supreme Court reestablished the constitutional validity of the death penalty under the Eighth Amendment. Welcome, Professor Lane.
Well, hi, everyone. First, I want to just say thank you. And Xavier, especially you. I mean, I'm listening to you, and already my remarks were, I am humbled to have been a part of this project. And, you know, listening and also reading about all the things that you've done, I'm just like, who does all that? Who does that? And I'm like, and he planted a flag in, like, you know, the North Pole, like, who does all that? So I am so humbled to be a part of this. And I just want to thank you for using your art to engage us and to be an activist. And frankly, to pierce, you know, the formality of the law. And that is nowhere more true than what you did with the Florida, with Proffitt versus Florida. You know, you really did just say, oh, really? That's what the law is saying? Let me tell you what's really going on. And so I just want to thank you for doing that work. And then I also want to thank Howard and Matthew for inviting me to be a part of this. I'm so honored. And I was saying before we started recording that this was one of the most fun projects I've ever done. And so now I'm just going to go on record and say, here's the real truth. It is the most fun. And I'm in my 20th year. I've done some fun stuff, but nobody has ever handed me a picture and said, the world's your oyster. You know, it's a blank canvas, literally, just write whatever you want to go with it. And so I loved this project. I loved this opportunity so much. And particularly as law professors, you know, we're analyzing and, you know, making these arguments. And this was a chance to kind of embrace the artistic side of the law and literature. So I'm so thankful to be a part of it. Okay, well, I've been asked to keep my remarks pretty short, and so I hope that we'll engage more in the Q&A. But Xavier's painting, and George, will you? Okay, great. You'll pull up there we go. So Xavier's painting is a depiction of Proffitt versus Florida. And for those who don't know, Proffitt versus Florida was one of 5 cases that was decided in 1976. It came under the headliner of Gregg versus Georgia, but it's one of those 5 cases decided in 1976 that brought the death penalty back. So some people don't even know that the Supreme Court actually invalidated the death penalty as it was then administered in 1972. That was Furman versus Georgia. And 4 years later, in 1976, the court brought the death penalty back by validating a number of statutes that the states had passed in the wake of Furman versus Georgia. One of those states that the court was considering their statutory schemes was Florida. And there we have Proffitt versus Florida. So it's a huge, huge landmark case. As Xavier says in his author's comment, which I also very much enjoyed, and you'll see I pulled from quite a bit, this is a fantastic painting. It's loud and brash, as he says, but he also says, you know, nothing is more fantastical, nothing is more existentially monumental than the death penalty itself. So there's a few themes, 2 in particular, that I want to talk about from my chapter. But before I get into those themes, the one thing that I'll know, just inspired by this moment in time is the person that Xavier gave us. And you can see, he's making a comment about who gets the death penalty. This is someone from a Black or brown community. And I just want to say he is right. He is spot on about that. And actually, the Supreme Court in 1972, 3 of those 5 justices talked about the death penalty's imposition on our minority communities. Justice Douglas famously said that the death penalty was pregnant with discrimination. I've always remembered that. But anyway, there's visualization, and I could talk for the full 20 minutes, but I want to point that out. And then I want to get to the 2 themes that I explore most deeply in my essay. First, you'll notice that on the sides, on both sides of the inmate here, there's a set of Roman numerals. There's 7 on one side and then an 8 on the other. Those represent the sentencing scheme that was at issue in Proffitt versus Florida. So Florida's guided discretion scheme, and the Supreme Court upheld 3 different guided discretion schemes in the Gregg versus Georgia cases. Florida's was one of them. But it required a judge to weigh 8 aggravating factors against 7 mitigating factors. When the aggregators outweigh the mitigators, the result is death. Well, Xavier resists this algebraic approach to death, which he says in his artist statement, and I quote, de-emotionalizes the death penalty so that it can be carried out. And he is so right. So the decision to give the death penalty is a profoundly moral decision that can really only be answered by the soul searching that comes with sitting in judgment of another person's life. Florida's sentencing scheme obscures this reality. It tells jurors that the decision of life or death is a matter of simple accounting. It's like some sort of algebraic formula where you plug in the values and you get the right answer. As I say in my essay, we numb ourselves with numbers. And that's what Xavier's painting shows us. Florida's sentencing scheme removes, or attempts to remove, the human element from the life or death decision. Xavier's project is about putting it back. And I tell you, that's why that this painting and this one alone went in a closet, because I think that that Florida likes his death penalty, and that was just too uncomfortable. You showed them something that they actually did not want to see. And he does this exceedingly well. I'll just say on this point that the social science research actually proves what Xavier illustrates so beautifully in this painting in 2 different ways. The Capital Jury Project, which is a National Science Foundation consortium of state research projects that interviews capital jurors to ask about their decision-making process. It found that in 2 ways, these sorts of guided discretion statutory schemes actually de-emotionalize and take the human element out of death penalty decision making. The first way is that jurors, and I was just reading the studies last night thinking about this lecture, but jurors in one study, 4 out of 5, in another one, 5 out of 5, actually did the algebraic formulations and thought that because the aggravators outweighed the mitigators, that they were required to give death. But literally, it was just a matter of math. The Supreme Court in the Gregg decisions actually said the death penalty is never required. So what the Capital Jury Project is showing is that jurors actually misread and misunderstand a scheme that authorizes the death penalty with a scheme that requires it. But more to the point, this second way is really what Xavier captures here. And it's just this notion that even when the jurors get it right, even when they don't think they absolutely have to give death, they de-emotionalize. You know, the law tells them this is a matter of simple accounting. It's a matter of adding up the pluses and minuses of your life and making a decision. And the jurors in the Capital Juror Project show that time and time again. And so I've got some quotes in my essay about that, but don't have a lot of time, so I'll just move on. So there's another part of Xavier's project that was really cool. So I'm just going to tell you, I'm not an expert on art, but I read Xavier's statement. He said that painting was itself inspired by a painting by Francis Bacon, which in just a moment, not quite yet. Oh, there it is. Well, Xavier's artist statement opens with the lines, and here's the lines that he says. Francis Bacon painted an image of a pope gripping the arms of his chair. I don't really recall when I first saw this beautiful piece, but I found it disturbing, perhaps because the sitting pontiff looked as if he was being electrocuted. Okay, now let's cue the picture. I just Googled, Francis Bacon and screaming Pope, and this came up. It wasn't hard to figure out exactly what Xavier was being inspired by. It turns out that Francis Bacon painted lots of popes, but this one was widely considered to be his finest masterpiece, the best pope he ever produced. And as I said in my essay, Bacon must not have liked popes much if that's his best pope. Bacon's pope wasn't a comment on the death penalty, but you can clearly see how Xavier was inspired in his depiction of prophet, and the themes that he was exploring, which I think I've just got 1 or 2 minutes left, so I'm going to hurry. But the themes that he was exploring: pain, imprisonment, isolation, obfuscation, they turn to be eerily apropos of the death penalty as well. So Xavier's painting is in dialogue with Francis Bacon's painting. And in the last minute or so of my remarks, I just want to hit those 4 themes. So briefly, the first is pain. Torturous, agonizing pain. You can see in both of these pictures that the subject has an open mouth, is screaming in pain. We don't know why Bacon's pope was screaming, but we know why Xavier's subject is screaming. And I'll just say that for a comment on the death penalty in Florida, the theme of pain could hardly be more relevant. Florida's electric chair was dubbed Old Sparky, and it was notorious for its frequent malfunctions and infliction of tremendous pain. I can remember Florida's Attorney General, if you can believe this, saying after one particularly gruesome execution, telling the press, and I quote, "People who wish to commit murder, they better not do it in the state of Florida because we may have a problem with our electric chair." This theme of inflicting pain is actually also true with lethal injection. I'm in the midst of a book project on that, but I'm going to have to just wave about it and move on. The second and third themes, very briefly, are imprisonment and isolation. And here I note Xavier's statement: he sits in a vacuum waiting for one of us to pull the switch. So I use this language, I use the dark background and also the cage that Bacon's pope is in to talk about the anguished experience of solitary confinement on death row, where inmates wait to die, spending 23 hours of their day every day in literally a cell that is the size of a parking lot space. And they do this for agonizingly long periods of time. Now the average time on death row just waiting to die is just over 15 years. The fourth and final theme is obfuscation. In Bacon's painting, you see the Pope is behind this thin veil. In Xavier's depiction of prophet, the obfuscation is the formulaic approach to death, which masks the decision-making process so we cannot see it clearly. Xavier forces us to cut through this obfuscation and to see the death decision for what it actually is. And for this, we can all be grateful, for as he says in the closing lines of his artist statement, in the end, it is all of us who have a firm grip on that switch. Thanks.
Thank you, Professor Lane. And by the way, she mentioned Q&A. If you have questions, you can put them in the chat, or when we get to Q&A, you can use the hand raise. Our next contributor is Linda McLean. She is the Robert Kent Professor of Law at Boston University School of Law. She is known for her work in family law, gender and law, and feminist legal theory. Her most recent book is Who's the Bigot? Learning from Conflicts Over Marriage and Civil Rights Law, was published in 2020 by Oxford University Press. She will be talking about Palmore versus Sadati from 1984, which declared that courts could not consider negative societal reactions to a mother's interracial remarriage in custody decisions. This case serves as a stark reminder that Florida is very much part of the South, with all of the racial history and racial baggage that carries. Professor McLean.
Thank you so much for including me in this program, for including me in the book, and to Xavier Cortada's wonderful paintings that provoke this engagement. I'm a very big fan of the idea of law of the arts, and as well as law and literature. So the painting invited me to consider how the artist's interpretation of the case might illuminate something about the case, which is a landmark case in family law where I teach, and also with constitutional law, with which I engage regularly as well. And the image of the family trio here, Linda Sidoti Palmore, Clarence Palmore, and Linda's daughter Melanie, facing forward with their backs to the sea of disapproving white eyes, suggests the legal victory that Mrs. Palmore achieved in a 1984 unanimous Supreme Court ruling that racial prejudice and concern about its stigmatizing effects on a child could not be a basis for removing custody from a fit mother. And in an often quoted statement, Chief Justice Burger wrote, "Private biases may be outside the reach of the law, but the law cannot directly or indirectly give them effect." So as I said, this is a landmark family law case and race and law case, and the painting captures the evident triumph of the family despite the sea of disapproving eyes. And some people may wonder why 17 years after Loving versus Virginia, in which the court held that Virginia's law barring interracial marriage violated both the Equal Protection and the Due Process Clause, why this problem could still be going on, but there was still a great deal of societal disapproval of interracial marriage in the 1980s. In fact, a classic study in 1982 found that Black-white interracial marriage was the most problematic form of marriage for many people. And in the courts, even though a person had a fundamental right to marry someone of a different race, when it came time to custody, as Melissa Murray has shown, white mothers would often lose custody because of their remarriage to a Black partner. So, as I said, there's a triumphant aspect to this painting, which kind of captures this notion that despite the sea of disapproving white eyes, the court says private biases may be outside the reach of the law. And the case has had a long afterlife in other civil rights struggles, such as gay rights. Mr. Cortada mentions the Miami-Dade Ordinance, which predated the Palmore case, but in the landmark Goodridge versus Department of Human Resources, the Goodridge same-sex marriage case in Massachusetts, Chief Justice Marshall cites Palmore in support of the idea that, you know, private bias is not a reason to deny people fundamental rights. Okay, the tragic aspects of Palmore, one of which is probably known to family law scholars and to some constitutional law scholars, is that the less visible aftermath of this case is a sobering example of how constitutional rights may be vindicated, but individual wrongs that spurred the case may persist. Despite her Supreme Court victory, Mrs. Palmore never regained custody of Melanie, who'd been in her father's custody, and he managed to game the state courts in Florida and Texas to keep custody of Melanie. By the time the court finally was ready to resolve the custody issue, the long passage of time worked in the favor of the father. And so when I did research for this chapter, I looked at newspaper representations of the case. And one photograph I found was Mrs. Palmore sitting next to Clarence Palmore, gazing forlornly at Melanie, right? So the family tableau is fragmented and never really reunited. And in 1986, there was a newspaper report that Mrs. Palmore signed papers giving custody to Anthony and retaining some kind of visitation rights, but she went a long period of time without even seeing her daughter. Another tragic aspect of the case that I discovered in researching it was something I had not previously known, which was that in December 1984, several months after the Supreme Court ruling, the marriage between Linda and Clarence Palmore seemed to be troubled. There were news stories that she had filed for divorce and was granted a temporary restraining order against him based on claims of physical abuse. A newspaper story several months later, referring to the famous court ruling, reported a domestic fight in which each was injured, but neither pressed charges. By August of 1985, they were divorced, as her custody case was still pending in Texas. Who knows what sort of influence these developments had on the Texas court, and it's also impossible 30 years later to know the strains on their marriage due to the prolonged custody battle or the power of prejudice to hinder healthy family life. And in my paper, I suggest that even though the painting depicts these disapproving eyes to the back of the couple, I might interpret this painting, if you look at the swirling motifs in Linda's dress, and there even looks like there's an eye shape in Clarence's arm or legs or her legs, you might say that the internalization of prejudice and bias could have a toll on healthy family life. I conclude my chapter by saying that fortunately the gaze turned on interracial and multiracial families as more positive and approving than it was 40 years ago, but not uniformly. And you could look at advertising to see the efforts to have more multiracial families, but then sometimes there's remarkable pushback against these efforts as well, as we see with various Super Bowl ads. In conclusion, I really have appreciated the opportunity to engage with this painting and its interpretation and to reflect on the gap between the triumphant look of this family tableau and the actual tragic aftermath despite the Supreme Court victory. Thank you so much.
Thank you, Professor McLean, and thank you to AALS for letting us go a little bit over time. Our final contributor is Laura Undercuffler. She is the J. Duprat White Professor of Law at Cornell Law School, where she has taught since 2009. She published her 2000 book, The Idea of Property, Its Meaning and Power, with Oxford University Press, one of many books and articles on property theory, constitutional law, and the role of moral decision-making in law. She wrote on one of the post-2000 cases that Xavier added to the series, Stop the Beach Renourishment versus Florida Department of Environmental Protection, in which the court found that there was no taking in Florida's beach renourishment project. And this might be the most Florida case in the book, because Florida tried to take steps to keep houses from falling into the ocean, and the homeowners sued for a Fifth Amendment violation. Welcome, Professor Undercuffler.
Thank you. I want to say that of all the pieces I have attempted to write in my career, this one was both the most difficult and the most rewarding. So it was a very interesting combination. I think that of all the cases in the book, the Stop the Beach Renourishment case is probably the most seemingly implausible for the project. The case dealt with the question of judicial takings, which is whether a state court decision that changes the law through clarification, interpretation, new policy, or other reason can trigger a federal takings claim. And as was just mentioned, in Stop the Beach, we had oceanfront owners who claimed that a Florida decision to replenish the eroding beach in front of their homes and to establish a public beach on the replenished area deprived them of their property right to contact with the water. And when the Florida Supreme Court ruled that they had no such right, then they changed their theory and claimed that the decision was a taking of property in violation of the federal Constitution. Interestingly, in the end, the US Supreme Court skirted the takings claim. It held that under Florida law, these individuals had lost nothing. The Florida Supreme Court decision had taken nothing from them. Therefore, although they offered bitterly discordant theories and views on the question of judicial takings, the question remained undecided. Now, if and when a judicial decision can be a taking of property is undeniably important. If judicial decisions can trigger takings claims, then the scope of the takings clause has expanded radically. So we might say we can see the importance of this case to law, but what about art? How does the abstract legal question in this case have anything to do with art? And when I saw Xavier's painting that went with this case, frankly, at the beginning, I was at a loss. I looked at this and I thought, there's no obvious imagery in the painting that portrays the central legal issue involved. Indeed, how could there be? The question before the court seemed impossible to visually portray. In Stop the Beach, the court's decision was presented in the careful, logical, closely reasoned terms we would expect in a case dealing with an abstract question of this kind. A painting, however, is an entirely different matter. The colors are vivid, clashing, harsh, and stark. It apparently portrays a piece of coast. A dark brown color, uniformly heavy in its tone, demarcates the upland area from the sand, and then a thick red line, incongruous in color, separates in turn the sand from the sea. The ocean itself is a roiling mass of black and blue. A snake-like pipe looms along the bottom, large and grotesque, a brooding and threatening presence in the sea. The pipe expels an avalanche of matter, bursting upward and outward, obliterating the beach and its red boundary line. The feeling overall when I first saw this was one of cold colliding forces upon a starkly outlined division of land and sea. So I thought, what does this picture have to do with the abstract question before the court? How does this imagery portray the central issue in the case? This is where the magical quality of this painting came to the fore. Ultimately, I realized that the relationship between the court's opinion and the painting was, in fact, the reverse sought. The painting was, in fact, a photographic negative, you might say, of what the court had written. A portrayal of what the case had addressed. It was instead a statement of what it had not addressed. The painting expresses the emotions that roil uncontrolled beneath the surface of this case. It presents the struggles of human against nature and human against human to control and divide where the land meets the sea. Harsh, heavy black and red lines mark human efforts to divide zone from zone and claim from claim. Although we tend to think that the boundaries that we draw on Earth are both magical and predestined, the painting's vivid and incongruous colors represent human zones of purported control, remind us that the boundaries we draw are, in fact, neither. Violent forces resist our hubris, our nourishment, our renourishment, our conquering, our parceling. Nature neither accepts nor respects our efforts at control. All of these boundaries that we draw, all the renourishment projects we engineer will ultimately be lost to the inexorable power of the sea. Reflecting on this, the court's opinion, which previously seemed appropriate, suddenly seems strangled and flat. Here we are in the nation's highest court with a case arising from the deepest struggles of human against nature and human against human. The painting is right in its unmasking of stark claims, violence, and the collision of spaces and forces, which are fought over every inch of coastline that divides dry land from the sea. Yet the court's opinion acknowledges none of these. It is a detached presentation of contextless arguments and analytical chess match on the courtroom floor. In trying to mesh the worlds of law and art, as this book does, there is a deep insight that I think can be found throughout the book. Art does not just illustrate the conflicts that the law presents. It does not only emphasize particular pieces in the story that the law tells. Rather, it compels us to question the boundaries, methods, and indeed the ways of knowing of the law itself. As those who have spent our lives immersed in the law, Xavier's painting haunts us. It haunts us because it foresees and forces us to see the smallness of the world that the law is usually deemed to be. Although the Supreme Court's ruminations and decisions in Stop the Beach are controlled, cerebral, and reflect what we would expect a court to say in a case of this type, the painting subtly and powerfully indicts the smallness of these processes. There is nothing controlled, limited, or cerebral about this painting. No matter how much we try to tell ourselves that the issues in the case are adequately presented by the court and by law as we know it, in the deep recesses of our minds, we doubt it. After our encounter with the painting, our way of viewing the case and the law have changed. So I thank you for a wonderful way for me to learn something in dimensions that I had never really thought before.
Thank you, Professor Undercuffler, and thank you to all of our contributors. We have about 7 minutes left, so we probably have time for a couple of questions. You can put it in the chat or you can raise your hand. And perhaps our speakers covered everything. That usually doesn't happen.
Howard, can I just say 30 seconds
Yeah,
more about?
please go ahead.
Yeah, the images of the eyes in the painting I engage with. One thing I didn't talk about because of interest of time is I argue that the state courts and the Supreme Court sort of turn their eyes away from Linda's plight. I mean, in other words, she had this legal ruling, but the court wouldn't order the return of the daughter to her. And that failure to give her sort of the kind of relief she wanted in terms of physically returning the child all worked against her. So there was a kind of, saying, we're not going to give credence to private prejudice, but then they didn't really engage with the reality of her very challenging family situation in which she'd been deprived of her daughter. And the longer you go on not having your child, the more continuity and stability are going to favor the other parent who does have the child. So the eyes, it was kind of like a failure to see, as well as these hostile, hovering eyes.
That very much, that ties in with some work that several scholars have been doing on what they've called the shadow docket, which is the orders docket from the Supreme Court, where they're staying or not staying decisions pending appeal that end up having more meaningful substantive effect than the ultimate ruling on the merits. And I think I was not aware of what happened in this case until I read your chapter, but this is a very good early example of that. Do any of seeing no questions from the audience, do any of our contributors want to add anything more? And if not, George, thank you very much for setting this up. Thank you again to the AALS art law section and to everybody who turned out today. A special thanks to Matthew, with whom I've been friends and colleagues for 2 decades now. It was truly a pleasure working on a project with him. Thank you all. Enjoy the rest of your day.
Thank you.
Xavier, I hope I hope they'll send your email or your contact information. I listened to your comments and said, I want to know him. I want to
Sure.
know that person.
It was in my slideshow. It's xavier@cortada.com. Absolutely. And cortada.com has all my contacts, cortada.com. Thank you so much, by the way. I mean, this was really meaningful to me.
Thank you, Xavier. This was
Xavier, thank
great.
you so much. And thank you all for participating. It's great
You
to
guys
see
were
you.
amazing.
It's a fun project. See you later. Thanks.
Bye. Nice
Bye.
meeting you.
Good to see
See
you.
you, Howard.
Bye.
See you, Karina.
Bye.